This quite extraordinary Queen's Bench case was decided in 1840. It followed from an earlier case, Stockdale against Hansard, which was decided in Stockdale's favour. The judgment in that case had to be executed, and it fell to two sheriffs of the county of Middlesex to execute the warrants. They did so in accordance with their duty. The House of Commons in England formed the view that by executing a warrant within the parliamentary precincts, the two sheriffs had committed a contempt of the Parliament. They were called before the bar of the House and were detained and imprisoned by the House's Sergeant-at-Arms on the authority of the Speaker, who in turn was executing a resolution passed by the House. Strangely enough, the warrant did not specifically say what the nature of the contempt was. The two men sought their release under a traditional writ called habeas corpus, which is a writ used by people seeking release from imprisonment by the Crown. The court found, however, that it was simply enough for the Parliament to state that the men were jailed for contempt. Once the Parliament had certified that, it was no longer possible for any court to look into the matter further, because the privileges of the Parliament were beyond the court's authority. Lord Denman said, "It would be unseemly to suspect that a body acting under such sanctions as a House of Parliament would, in making its warrant, suppress facts which, if discussed, might entitle the person committed to his liberty." Justice Littledale said, "Whether or not in the present instance it is right to visit any person with the anger or the justice of the House of Commons is a question with which we have no concern. On ground of law, the only grounds we have a right to proceed on, we cannot order these gentlemen to be discharged." By these judgments, the courts maintained the separation of powers between the judiciary and the legislature. They refused to second-guess the conduct of the Parliament in protecting its own privileges. In Australia, the Parliament has only once relied on its powers to jail people for contempt, but it was very clear that just like in the United Kingdom, the courts in Australia would not question the power of the Parliament to punish for contempt.